That's a store I haven't been into in a long time as well. Since my kids were young. I mean, when your children get older, you don't do as many things as you used to. So
Mr. Chavez, we are
yes,
now
sir.
live.
Oh, good. Okay. So let's go on the record. We are on the record. Good morning, folks. Today's date is March 11th, 2021. My name is Stephen Chavez, the city's land use hearing officer, and we're here for a time-sensitive quasi-judicial administrative appeal, an appeal from the zoning hearing examiner, and it is numbered AC 21-1. This hearing is also being recorded by, looks like Miss Visaraga. Did I pronounce your name correctly, ma'am? Anyway, Ms. Visaraga is a certified court reporter, so she will be taking recording of this hearing, and there will be a transcript, an official transcript of this. If you want to obtain a copy of the official transcript, you have to contact Ms. Visaraga, and she will provide you one with a fee. I believe there's a cost to it. It's like a deposition transcript. So now the procedure for this appeal is as follows. The appellant will make an argument. I understand Ms. Walker is the agent for Mr. Hoffman. And Ms. Walker, you will be given time to make your argument. Then if there are any party opponents, they will be allowed time to make a counter argument. And Ms. Patton Quintana can make a record if she so chooses. I may have some questions for Ms. Patton Quintana. It's certainly anybody who testifies is subject to cross-examination as well from the other side. And then after we finish that, Ms. Walker or Mr. Hoffman will be allowed time to make a closing rebuttal argument if necessary. Are there any procedural preliminary matters that we need to take care of before we go into the merits of this appeal? Ms. Walker, any issues that you have regarding this, regarding the process or regarding the evidence in the record? If you'd like to supplement the record, this is the time to do it. Ms. Walker?
No, I believe everything that we needed to submit to supplement to the record was submitted ahead of time. Okay. Everything else was submitted prior and previous.
Okay, well, let's get started. Let me swear you in. Okay, so please raise your right hand. Do you affirm to tell the truth, the whole truth, and only the truth?
I do.
Okay, go right ahead. And I may interrupt you, hopefully politely, if I have questions regarding what you just said. Okay?
Okay, perfect.
Go ahead.
Okay, good morning. I just want to say good morning to everyone on both sides of the issues, everyone from the city, the planning zoning department, and everyone who's watching and participating virtually today. I just want to first acknowledge the reason we're kind of here today is, of course, because of the fence, but in the beginning, there was a lot of misunderstanding. There was a lot of confusion as far as what was a circumstance, what constitutes a circumstance, and stuff like that. So in the beginning, I was just, I kind of stepped in to help Gary and Brad, and I did the best I could with what I had available at the time. But now that I've had time to actually do the due diligence and sit down and read the IDO and look at overlay maps and kind of really get an understanding of, the situation at hand. So I want to start out with kind of talking about what I found. What I see is during the ART project, during the construction, during the building, there were a lot of, I guess we could say, unforeseen, circumstances and consequences that come with any project, And I just kind of believe that that's what we have here because we are being negatively impacted, and it was something that was not, because of any cause of our own or anything like that. Like I said, it bit down to the art project because one of our main issues is going to be the semi trucks and the deliveries and stuff that are going on, right along. There's actually a truck that left maybe 5 minutes ago, but that's only part of the issue because, I mean, naturally, before the art project, they were able to make their deliveries in and along the medians on Central. And now that they're not able to do that and access the front of the buildings, naturally, the easiest solution is going to be to access the rear of the building. So it just kind of comes with it. I don't think it was thought about. I don't think it was planned. But since then, since the traffic and stuff has picked up, the city has come out and actually marked parking spots, put a 2-hour parking sign out there. So it's actually like become parking for the Silver Business District, for the Nob Hill businesses. So this Silver Avenue has really, really picked up now that the art has affected Central. And that also puts us in a unique circumstance because it puts us actually in two that I want to talk about. One that I found is the 1/8 of a mile radius that is around the art stations, which are designated by the city as premium transit corridors. And this property, which is a mixed use property, falls within that premium transit corridor. Before that, with just the regular public transportation and the bus and stuff like that, we already fell into a major transit corridor. So that puts us in two different situations than the residential, to this side of us. It puts us in a really unique situation because there's only 4 properties in this area, the Silver, the
Richmond, Silver.
Yes, the business district, pardon me, that are zoned the same way that we're zoned, the MXT zoning, and they're corner lots, and they're in the premium transit corridor as well. So that makes us unique in and of itself. We don't just fall into one corridor, we fall into 2 because of how close we are. I mean, Silver is literally right on the other side of the wall for me. I mean, and it bustles. We have we have the traffic, we have the bicycles. It is Bicycle Boulevard. We have, just a lot going on, especially now that things are opening back up. We have just a lot going on. So I think just those factors in themselves put us in, makes this a special circumstance. The fact that, I mean, I kind of want to refer to the IDO itself, because when you look at Part 14.16.2 that refers to zone districts, 2-4A1, it gives the definition of a mixed use purpose, the purpose of a mixed use. And it says, the MXT zone district is to provide a transition between the residential neighborhoods, which we have to this side of us, and the more intense commercial areas, which we have to this side of us, which would be Silver, which would be Central, which would be everything that's here. So that, we're zoned to be a buffer. We're zoned to absorb that transition. Now that we understand that being zoned the way that we're zoned, there's a purpose for that. And that purpose is to be a buffer to the neighborhood and the residential area. So that way they're kind of able to have the peace and quiet, because I realize, there's a lot of neighbors and stuff that say, well, we don't see the trucks. We don't see. I understand.
Okay, I didn't hear you for a moment there. You went off audio.
Oh, I apologize. But no, I was saying there's, people that have their opposition, and I understand, there are people that oppose. They're welcome to their opinion, but they don't have the same experiences, I guess you would say, because we're serving as that buffer. So that way the neighborhood is able to live peace and quiet, and they don't have to deal with the hustle and the bustle and the trucks and stuff like that. And we're okay with that. But all we're asking for is our own buffer. We're asking for some sort of a buffer from the noise pollution, from the trucks, from the fumes. Like, we understand that there's nothing that we're going to be able to do to stop the trucks. They're going to deliver, they're going to do what's easiest for them. Coming around the rear is the natural solution. And we understand that. We understand that. But all we're asking for is to be able to peacefully enjoy the yard. When there's trucks delivering, there's all this hustle and bustle, it's hard to even sit outside and have a cup of coffee, because we're dealing with trucks idling. They're pulling all the stuff off the back of their trucks. They're leaving the trucks running. So you have the fumes, you have the noise.
Ms. Walker, may I interrupt you?
Yes.
Thank you. The standard for my review of the ZHE's decision is to decide whether or not he erred in some way, whether or not he erred in the facts or in applying the law, or in some other way. I can tell you that I agree that the ZHE erred, but I don't agree that he erred with the argument you're making. You're making a very good argument. But I don't think this is a special circumstances analysis. That is, I don't think the standard for a variance using the special circumstances criteria, the 5-prong test, which includes the special circumstances criteria, applies in this case. It seems to me, and I've read the entire record, it seems to me that the ZHE erred in applying that standard. I believe that.
And I have one other thing I want to
Sure,
share.
and I'll let you finish. It's my belief that this is a variance test under the standard under 3C. The ZHE applied 3A, which includes the special circumstances analysis, which is a very difficult analysis to meet. It's extremely burdensome. But it seems to me under 3C, the analysis applies, because even though this isn't a residential zone, it abuts a residential zone, number one, and there is a residential lot. Mr. Hoffman's lot it's my understanding that it's a residential lot. Is that true? Is it a residential lot?
It's zoned mixed use.
No, I understand the zoning.
Oh, but is there a residence? Yes.
But its use is for a residence. It's for a dwelling unit, correct?
Yeah, correct.
Okay, so under 3C, if his zone abuts a residential zone and it is a residential use, then we use that analysis to determine whether or not the variance should be applied. And the ZHE erred. It looks like he determined that because it's an MXT zone, that the special circumstances analysis applies, but that's not true. And the language of 3C, if you read it carefully, it demonstrates that because it's a residential use, and because this is a use that abuts a residential zone, it doesn't matter that it's an MXT zone.
Okay.
That analysis applies. And so I would be my decision to remand it back to the ZHE to apply that analysis. And that analysis is pretty in depth too. There are lots of prongs for it, but it seems to me that it would be easier to meet the test using that analysis.
I agree.
Residential use.
And that was also something that I asked in the appeal, as I'm sure, like you said, you read over everything, but that was.
Yeah, you were concerned that the wrong test was being applied. Yeah. I saw that. You had questions regarding that.
Exactly.
So I understand that. So I'm not trying to stifle your presentation. It's a very good argument, but I just don't think that the analysis is for a special circumstance, because this is not a commercial use, clearly.
Yes, I agree.
Do you have any more, anything more that you would like to add to the record?
The only other thing that I just wanted to get on record, because I know in the original, we had a lot of talk as far as the opposition, but we submitted a couple of documents that were never, they were never brought on the record, as far as the petition that we had signed for people in favor of it. So I don't think that without seeing both sides, the opposition as well as the people that were in favor for it, I don't think any person could have reasonably, not used that in their decision. If you only are able to see, well, I see, 5, 6, however many people that are opposed to it, but I don't see anyone that's for it. But that was not the case. There was a petition that was signed. There were neighbors that were, in favor.
It's not a referendum. I mean, if 100 people signed a petition opposing it and 100 people signed a petition favoring it, I mean, it doesn't matter, because this is not a referendum. It's not. If it were a referendum, we would put it up for a vote, and it's essentially whether or not you meet the test in the IDO.
Okay.
So, I mean, I'll leave that for the ZHE, but that's the analysis. It seems to me that the difficulty in the analysis under 3C for you is the 20% rule, and Miss Patton Quintana can describe that to you later, maybe at another time.
Okay.
I know the area well, because I lived in that area when I went to UNM, and so I know it's changed a little bit, but I know that there are lots of front yard walls that are over 3 feet, and so you have to demonstrate that at least 20% within a certain distance, certain proximity, are 3 feet or above 3 feet actually.
Yes, and we actually worked with.
I'm guessing you would meet that. I'm just speculating. I don't know. The ZHE would need to apply that analysis correctly, and you would need to provide him with the evidence for that analysis. The other test, which would be difficult, is whether or not it harmonizes in something with the other fences. That is, whether or not it looks the same and same kind of materials, things like that. That would be difficult because this is a vinyl fence. But I'll leave that to the ZHE to determine. Certainly, there are considerations that can be nuanced in front of the ZHE. So those are the issues. I don't think that, I know that Miss Patton Quintana referenced that the 2020 update, the IDO's 2020 update would apply to this case. I don't think it does. I'm fairly certain it doesn't, but I have some questions to make sure that it doesn't apply, because under certain sections of the IDO, we know when a update applies, because it's very clear. There's very clear language, but we have to do a factual analysis for that. And it looks like the record demonstrates that the application was submitted on the 14th of October, 2020, and then it was set for a hearing on that same day. The hearing was set for December 15th on that same day, October 14th. So if those are the facts that are correct, then the 2020 update does not apply clearly under the IDO standards for complete application. But I'll ask Ms. Quintana whether or not those facts are correct. Is there anything else you would like to add, ma'am?
No.
Okay. Is there anything Mr. Hoffman would like to add to the record? I'd have to swear him in if he does.
Okay, hold on one second. No, we've presented everything. We've looked over. I think that we're okay.
Okay, Ms. Walker, thank you. That was a wonderful presentation. Is there anybody that would like to cross-examine what Ms. Walker testified to? Is there anybody on this live streaming? Okay, Ms. Patton Quintana, I have some questions for you. May I swear you in?
Yes, sir.
Good. Please raise your right hand and let me know that it's raised.
It's raised.
Okay. Do you affirm to tell the truth, the whole truth, and only the truth?
Yes, I do.
Thank you so much. So I noticed that you indicated that you believe that the 2020 update applies, the November 2nd, 2020 update. And so I looked at whether or not it would apply or not. And it seems to me that the record supports that the application was submitted on October 14th, 2020. Is that correct?
That's correct.
And then it was set for a hearing for December 15th, but it was set on that same day, October 14th, because it's in the application. Is that correct too?
Yes, that's correct.
Okay. So is there anything else that I mean, is there a reason why you believe that the 2020 update applies?
No, I apologize for the inconvenience.
No, it's not an inconvenience at all.
What is it, the 2018 IDO?
Yes.
The earlier one is what should have applied because of the application date of October 14th.
Right. And under the application completeness, and the reason why I know it so well is because I've dealt with this in land use appeals. There have been some appeals dealing with when the application was submitted and when it was complete, when it was determined complete for purposes of which update applies. And as you probably know, under 6-4H, we look at what the date that it was determined to be complete, and we assume that it was determined to be complete when you set it for a hearing. So because you have to have a complete application before a hearing can be set under the IDO. So the assumption is if you've set it for a hearing, then the application was complete. So I'm assuming the application was complete on October 14th, 2020. Is that correct?
Yes, sir.
Okay, good. So then the 2020 update does not apply. The 2018 IDO applies. And the significance of that is that for the distance, I think it's 330 feet for the 20% rule. I know that there's been some misunderstanding about how the 330 feet is measured, but the city council has already ruled by implication when they approved or accepted my recommendations on other appeals, that the 330 feet, it's not a linear 330 feet. I know the update, it's a linear 330 feet. That is 330 feet on the block. But under the existing 2018 IDO, the 330 feet is a radius, okay? So it can be any direction. So and the reason why I'm explaining that, Ms. Patton Katana, is so that when you get with the applicant and the applicant's agent regarding the remand criteria, you want to make sure that you let them, you give them enough information to do that analysis, 330 feet radius.
Yes, sir. I truly appreciate that clarification. Thank you.
You bet. And so I will draft a remand, because remand decisions are essentially decisions. They're not recommendations to the city council. Expect a remand decision within the next week or so, and then the applicant can start anew. And I apologize that you folks have to start anew for this with the new analysis, but we want to make sure that it's done correctly. There's another process. You can also, and you should consider this, you can also withdraw your application and resubmit a new application under the 2020 update, because there are exceptions under the 2020 update that would allow you to, I don't know if it's easier, and that might be too strong of a word, but there are exceptions that would allow you to keep the fence at that height based on issues of vagrancy and safety issues, I believe. I believe that's in the 2020 update, but not in the 2018. So consider all those issues. But for now, I will draft a remand instruction. Okay. Miss Walker, do you
Thank
have
very
any,
much.
Miss Walker, do you have any cross-examination questions
No.
for Ms. Patton Quintana?
I do not know. I've taken notes on everything that you discussed with her, and like I said, I'll go over it and we'll, kind of decide what the next step will be from here.
Okay, well, good. I mean, I'm not challenging the ZHE or his rulings. He's a very, very smart guy.
Yes.
It's easy to look at people's decisions with 2020 hindsight. Certainly, I've been looked at many times like that. So I think it was an honest mistake. So,
Thank
okay?
you. Thank you. We appreciate the opportunity to come before you and everyone today and just kind of explain our, where we're coming from and just kind of explain, the discrepancies and the issues that we have.
Sure.
So thank you. We appreciate everyone here today. Thank you.
I have another question. Is the lot less than, I assume it is. I mean, it's just not in the record. The lot is less than 1/2 acre, correct?
Yes.
Mr. Hoffman's lot?
Yes.
Okay.
I don't have the exact size.
No, I don't need the exact, but it is less than 1/2 acre.
Yes. Yes.
Okay, that's what I thought. I mean, it looks like it is. It looks like it's probably less than 1/3 of an acre, but
That sounds about right.
yeah. So, okay, good. Is there anything else that we want to go over before we go off the record?
No, I think we're fine on our end. Thank you.
Okay, I will submit my my instructions, the remand instructions, to everybody simultaneously, probably sometime next week, and I'll do it via email. Okay. Great. Thank you so much. Let's go off the record. Have a great day.